looks like we're good to go here. We were waiting for the YouTube feed to start up, and it's going. So I will go ahead and call the case and introduce us and proceed. This is the Kansas Court of Appeals sitting in a special setting by Zoom to take up the case of Wesley Properties Management versus Geoffrey Hill, Jenny Andruck, and Zachary Andruck, case number 124428. My name is Gordon Atchison. I'm the presiding judge today. Joining me are Judge Anthony Powell, who came on our court in 2013, and Judge Sarah Warner, who joined us in 2019. And I've been kicking around here since 2010. So that is the panel. It's an experienced group of Court of Appeals folks. I will remind counsel we have read the briefs and are familiar with generally the factual background and that sort of thing with the case. So you don't need to give us, unless you want to, a long factual introduction. The case has been set for 15 minutes. Mr. Cummins, as the counsel for the appellant, you may reserve a portion of that 15 minutes for rebuttal. If you will tell me at the start of the argument how much time you wish to reserve, I will do that. And I'll get my timer started. I've got a new smartphone that's smarter than I am. I'm figuring it out. Mr. Cummins, while we don't really have a lectern, but the stage is yours. You may proceed.
Thank you. Your Honors, and may it please the court, my name is Dan Cummings, and I represent the defendants appellants in this case, Jenny and Zachary Andruck. And with the court's permission, I'd like to reserve 3 minutes of time for rebuttal.
You may do that. Please proceed.
Now, as the court is aware, this is an eviction case. Last year, the Andrucks were left homeless for several months after they were wrongfully evicted from their apartment in Leavenworth. And as the court saw from the parties' briefs, however, this is not your simple, typical run-of-the-mill eviction case. There are a number of different legal issues at play in this appeal. But what I hope to accomplish this morning and to emphasize to the court is that while there are a number of issues in play here, the path for resolving this appeal and this litigation is actually quite straightforward. This appeal can and should be resolved on the basis of standing. Now, standing is a threshold jurisdictional issue that must be resolved before proceeding to the merits. And I believe that in this appeal, standing is dispositive. Now, both sides have briefed all the issues here very thoroughly, and I'm happy to answer any of the court's questions you may have about any issues. But because I believe standing is dispositive here, I plan to spend most of my time this morning focused specifically on standing, unless the court has questions on any other subjects.
Well, before you get to the standing argument itself, you also, in your brief, talk about capacity, which is a real party and interest issue. And those are related but different concepts. The real party and issue is a correctable defect. The lack of standing would not be. Do we have to resolve the real party and issue before, or real party and interest issue before we get to standing?
I don't believe that you do. As you correctly observed, I mean, these doctrines are parallel in many ways. Substantively, they're very similar and generally overlap, but standing is jurisdictional, whereas real party and interest is not. And as you said, the capacity issue is correctable. So I think if you resolve this appeal on standing, then you may not need to address the real party and interest. I guess what I was asking is,
if you get to standing first and there's a real party in interest issue, then you never get to that. I mean, it seems to me there's a question that you raise as to whether Wesley Property Management, the management company, is the correct party to bring this. Is that a real party in interest issue with respect to Wesley Properties, the actual property owner, especially given that they are similarly situated, that there is a single stockholder, they have some connection to one another. And it's not a misnomer here, but is it a real party in interest issue that we should take up? If we take it up as standing, we never get to that question.
I think that's correct. I mean, certainly the court could address both. So, I mean, the standing issues also go towards the real party and interest analysis. So the court could just address standing, or it could address both issues.
Okay, but if we address the real party and interest issue under 6217, that's correctable in some fashion. What winds up being the remedy at that point if we think that it's a real party and interest issue?
So if it's a real party and interest issue, standing is still a jurisdictional issue and a threshold issue. So the court would still have to address the standing issue first. So you could address standing without capacity, but I don't think the court could address capacity without standing, given that it goes to the court's very jurisdiction.
Okay, well, that gets back to the conundrum I was positing beforehand, is that you never get to the real party and interest issue to correct it under that analysis.
Yes, and I believe that the correct way to address this is by addressing it based on standing.
Okay, well, go ahead then. I've diverted you here from your argument, so go ahead with your standing.
No, Your Honor, I'm here to answer your questions.
Well, good. We'll think of some more for you.
All right. So the plaintiff in this case is Wesley Property Management, or WPM for short. They lack standing here for three primary reasons that I hope to flesh out a bit more. First of all, they're not the property owner, and this is undisputed. A separate company owns this property, so they have no property interest to enforce. Second, they are not suing the Andricks to enforce a contract. Right? They have taken the position, for strategic reasons or whatever the reason is, they have taken the position that the Andricks have no legal right and are unauthorized occupants, not tenants. And the upshot of this is they're not trying to enforce any contract between them and the Andricks. So they have no property interest to enforce, and they are not trying to enforce any contract interest. So they have no legal basis here as to have standing. Now, a third and independent reason that we address in our opening brief is that they have failed to carry their burden at trial of establishing that they had actual authority from the property owner to enforce the property owner's legal rights. So for these reasons, that they have no property interest to enforce, they're not trying to enforce any contractual interest they might have, and that they fail to prove actual authority, we believe that WPM lacks standing here. Additionally, I'll note.
Let me
Yes, Your Honor.
pose another question to you. Under the Kansas Residential Landlord Tenant Act, it would appear that Wesley Property Management is definitionally a landlord because the lease does not identify the property owner. Would you agree that the lease does not identify the property owner?
Are you talking about the implied, in fact?
No, I'm talking about the signed lease with Mr. Hill.
I believe it does identify the property owner.
Oh, okay.
As I recall.
All right, I looked through it and I didn't see that, but assume with me, at least for right now, that it does not identify the property owner. Statutorily, does that make Wesley Property Management a landlord under the Residential Landlord Tenant Act?
That would depend on the context in which landlord is being used. They could be a landlord vis-a-vis Mr. Hill or Ms. Kell.
Okay. Are they a landlord for purposes of ousting someone who has no contractual right to be on the premises and is squatting effectively?
No, because they have no legal interest to be enforced. So they're not the property owner. They have no property-based interest there, and they have no contractual-based interest that they're trying to enforce. So there's no legal right to be enforced there that belongs to them as opposed to the property owner. Now,
Mr. Cummins, I might agree with you if this were just a common law kind of issue, but here we have statutes under the Residential Landlord Tenant Act that define things like the landlord and then provide the landlord with some legal rights, right? And so if the Residential Landlord Tenant Act provides the landlord, as it is defined under that act, the ability to evict someone who isn't subject to a written lease or doesn't have the authority to be present on the premises, wouldn't you agree that the plaintiff here does have that authority?
No, Your Honor. Standing is a constitutional requirement. It's inherent within the grant of judicial power given in the Constitution to Kansas courts. So because it's a constitutional requirement, the Landlord-Tenant Act cannot stretch standing beyond what has been traditionally recognized as legal standing within a court system.
Regardless of what the statute said.
Regardless of what the statute said, it's a constitutional requirement, and I think there's ample case law saying that standing is constitutionally based, and then the constitutional hook for that is the grant of judicial power, right? Adjudicating a case where a plaintiff does not even have standing, any legal right to be enforced would exceed the judicial power granted by the Constitution.
But can't a statute confer standing that would satisfy the constitutional requirement?
Yes, Your Honor, if it satisfies the constitutional requirement.
No, well, that's circular. I mean, can't a statutory grant be sufficient for constitutional standing? And wouldn't it typically be? I mean, is there a circumstance where a statute would grant a right or a cause of action and it wouldn't be sufficient constitutionally?
Yeah, if it went beyond your traditionally recognized basis for standing, then that would be the case.
Okay. Go ahead.
So I'd like to turn now, if I could, because I think what Your Honor's maybe getting at is WPM's standing argument. So as I read their brief, they only have one argument in favor of standing. So why they have standing despite not trying to enforce a contract and not having any property interest in this property, which is KSA section 582552. And there are a few problems with this argument. First and most primarily is that it relies on taking this statute out of context, right? This statute addresses a landlord's duty and ability to deliver possession of property to a new tenant. And in order to fulfill that duty to deliver possession to a new tenant, the landlord may need to sue for possession on any holdover tenants or anyone who's wrongfully in possession of the property at that time. But it applies within that context where the landlord has signed a lease with a new tenant and has to deliver them possession. That's not the case here. There's nothing in the record about WPM, renting this to somebody new and then having a duty to deliver possession. So this is a very narrow statute.
Does the statute say that? I mean, there's two sort of independent ideas in separate sentences. You're linking them together, it seems to me, with sort of inferred or invisible language that's not there. Are you saying they're just that closely linked because they're in the same statute?
Well, certainly context is a critical part of statutory interpretation. Additionally, if this was read to be this broad catch-all statute, it would be duplicative of a lot of other more general eviction statutes. And it also specifically says, it doesn't say any landlord, anyone who's a landlord may bring this eviction suit. It says the landlord, right? Well, which landlord is talking about? Well, that takes you back to the first sentence, which is a landlord who's under a duty to deliver possession to a new tenant, right? That's the landlord.
You're going into your rebuttal time now, which you're free to do, but you won't get it later.
Your Honor, thank you for pointing that out. I'll reserve the balance of my time.
Very good. Mr. Nelson, we're ready to hear from you. You have 15 minutes.
Thank you, Your Honor. Well, I'm Gary Nelson. I represent Wesley Property Management. And I guess I'm a little confused on his standing issue, because the statute says a landlord can file suit to evict someone. That doesn't require them to be a tenant. And his argument that since we had no new tenant, then we didn't have statutory authority. Well, I think
okay, is Wesley Property Management a landlord for purposes of this case? I mean, since I think it's conceded Wesley Property Management does not own the property.
That's correct. They do not. They are the landlord. They were the landlord when Mr. Hill and
well, I'm asking why they're the landlord. What makes them the landlord?
Well, they rent the property for the owner. And they have for years. They couldn't get a new tenant in there because we couldn't predict the move out date of the old tenant. Plus we had, multiple things to do to the property before we could rent it. If the eviction started, I believe, in August. If we'd have rented it for September occupancy, we couldn't have delivered. And we didn't have.
I understand that, but you still haven't really gotten to my question. And I understand that Wesley Property Management meets with the tenants, handles in and out, maintenance requests, all of that. What makes Wesley Property Management, though, a landlord for purposes of bringing an eviction action?
They're the ones that leased the property. They leased it before, they leased it afterwards. They are the landlord. There's no one else to manage this property.
Well, the owner is the owner a landlord?
No. The owner is not a landlord for the purposes of this piece of property. The owner.
Are you saying that the landlord could not bring an eviction action in this case?
They probably could have against an unauthorized occupant, but they weren't. The landlord was not, or the owner was not the landlord in this with respect to this piece of property.
Mr. Nelson, I'm trying to clear up a little bit of what you're saying. Are you saying that the owner was not the party to the lease on this particular, so this owner was not the lessor of the property?
That's correct.
But the owner is still a landlord, a statutory landlord under the Residential Landlord Tenant Act, right?
Right.
Okay.
They also argue that Wesley Property Management does not have a contractual or a property interest in this property. Well, they manage this stuff on a commission basis. And if they have the ability to lease this out, then they've got a property interest, and they're just at a loss when they can't lease it out.
Mr. Nelson, is it in the record someplace in this case that Wesley Property Management is compensated in part on a commission basis?
I don't know that was in there, that their method of compensation was in there. It was testified to by Mary Garrison that they have an agreement with the landlord to manage the property. And I don't think they got into the compensation part of it.
Okay, go ahead.
I'm not sure that the compensation part was relevant to the eviction of unauthorized occupants.
Well, you just raised it as indicating why they had a property interest, and there, at least on the surface, that seems to be an interesting argument. I don't recall seeing anybody referencing the record, though, where that's in the record.
I don't think it is in there. Their compensation for managing it, I don't think was actually part of it.
Okay, go ahead.
But they are, since they were the landlord, they did have standing pursuant to the statute. Since they were the landlord, they're the real party in interest, and there was no lease to terminate. These Miss Andrick had picked up an application for a lease, but never turned it in. And don't know why she didn't turn it in, but she didn't. And Mr. Andrick defaulted. He never appeared for any of this stuff. So I'm not exactly sure why he's even a party to the appeal when he defaulted. But, one of their other interesting arguments was this supersedious bond. How does the court set a supersedious bond when there's for unauthorized occupants that have no lease? They would have to create a contract to do that. The appellate argues that they had an implied contract, but they didn't. They had Wesley Property Management had a written contract with Mr. Hill until he died. And there wasn't anything to go forward with these unauthorized occupants.
Mr. Nelson, could you address the notice, the written letter that was posted on the outside of the door, which in my understanding was posted after Mr. Hill's passing by Ms. Andrick? Why did that not provide notice of kind of an assumed lease? That seems like that's what the argument was.
Well, I think Mr. Cummins argued that it didn't say that it was terminating the lease. Well, there was no lease to terminate. It was just a forcible detainer notice. Action will be brought against you to regain possession.
And that is my fault. I was talking about the written letter that Ms. Andrick posted, not the letter that the landlord posted.
Why her letter didn't imply a lease?
Well, no, yeah, I was just wondering if you could address that piece of evidence. That seems like the strongest piece of evidence that she has, in my view, as to kind of providing notice to the landlord of an assumed lease or an assigned lease or something along those lines.
Well, she can say whatever she wants to say in a letter or to them, but that doesn't create an implied lease, even though she may think it does or wish it did. But there can't be an implied agreement without some acquiescence on the part of the landlord. And there very apparently was not any acquiescence on the part of the landlord to enter into any type of lease with these people. So I don't see their argument of an implied lease or that they were implied tenants or any of that stuff as having any merit whatsoever. The judge in the district court heard this case, and it seemed like it went on for weeks. We had 3 different hearings in it, and he made a finding based on all the evidence that they were not tenants. And I don't think she can imply that they were simply by writing a letter. There was no acquiescence on the part of the owner to create an implied lease or implied authorized occupancy. So I think on the issue of standing and real party and interest, there wasn't anybody else to bring this action. And I think the Landlord Tenant Act is drafted to allow absentee landlords. It's a very common situation that the legislature most likely took into account when they drafted this piece of legislation that allows the landlord to evict unauthorized occupants. And I think there was a implication or maybe it was addressed directly in their brief that the Leavenworth City Commission had passed something that put an extreme broadened definition on landlords and tenants, but that doesn't have anything to do with the Kansas Landlord Tenant Act and evictions in district court. It would affect only what would go on in municipal court. They don't have the authority to expand that. And just because they live there and without authorization for a period of time doesn't make them tenants. But I don't know, be happy to address any other questions.
Well, we don't penalize anybody for not using all their time. I don't hear any other questions. You still got a couple of minutes left, but if you've said what you need to say, that's more than fine.
I believe I've said what I have to say, Your Honor. Thank you.
All right, very, very good. Mr. Cummins, I assume you are still there. You kind of went blank. Oh, there you are.
Yes, Your Honor. I'm just
Okay.
sitting down at the table here. I'm at the end of a conference room table.
Very good. Well, you have 3 minutes. Go ahead.
So just a few points briefly on WPM's standing argument under KSA 582552. As I mentioned before, this relies on taking this second sentence of the statute out of the context in which it applies. Another problem with it is that this argument does not even work on its own terms. They argue that they're landlords because they leased the property to Mr. Hill and Ms. Kell. Well, this was a 1-year lease that had already expired. Ms. Kell had moved out very early on. She was released from the lease. That was the testimony from their office manager. So they're not leasing to her at any point. Mr. Hill was continuing on a month-to-month, and then he had passed away prior to the filing of this lawsuit. So they were actually not renting the property to Ms. Kell or Ms. Hill at the time the lawsuit was filed. So even their argument doesn't even work on their own terms based on that lease. Additionally, I should mention that. Yes, Your Honor.
Would it be your position then that the Andricks had a month-to-month tenancy?
Under the Landlord Tenant Act, that is the default when the lease does not specify a term. So
Okay.
yes.
All right, go
That's
ahead.
a yes. Another problem is that even if their statutory argument were correct, this does not get around the requirement of them having actual authority from the property owner here to enforce the property owner's legal rights. They failed to carry their burden on that at trial, as we address in our opening brief. And then additionally, as I said, standing is a constitutional requirement. There's ample Kansas case law that says standing is a constitutional requirement. If that could simply be trumped by statute, I'm not sure what that even means for it to be a constitutional requirement. And I'm not aware of specific Kansas case law on this, but federal case law from the U.S. Supreme Court has certainly said that the mere existence of a statutory right of action still has to meet the constitutional requirement. You cannot trump the Constitution with a statute. And so the U.S. Supreme Court has said that in cases like Spokio and TransUnion within the past decade, very explicitly. And finally, I would just say WPM is trying to enforce property rights that it does not have. It has no property rights. It's not the property owner. Doing tasks on behalf of the property owner for commission does not create a property right. Right? They are very clear they're not trying to enforce any contractual right. They said there is no contract. So they have no legal interest that they are seeking to enforce here. The right to sue unauthorized occupants for eviction, which is purely a property-based right that's being enforced. That right belongs solely to the property owner. WPM has no standing here because they are not trying to enforce their own legal rights. There are no other questions for the court.
Well, you've used up your time anyway. So
Okay.
We're at the end. Gentlemen, I appreciate the arguments and the briefs. There's some intriguing issues in this case. We will take it under advisement and get out a written decision as we are able. And with that, we will adjourn today. Thank you both.
Thank you, Your Honors.